All right. Good morning, everyone. Welcome. So just real quick, the goal of today is to provide you guys with a perspective from both the billing and the litigation perspective on optimizing collections for your business. So real quick, if you have any questions, please feel free to put them in the comment box, and then we'll get to them after for some Q&A. And so I'm going to go ahead and pass it off to Zach at this point.
Great. David, would you advance the slide, please? Terrific. Thanks. So my name is Zach Rothenberg. I am one of the partners at the law firm Nelson Hardiman LLP here in Los Angeles. We are a full-service law firm dedicated solely to representing healthcare providers and healthcare entrepreneurs. We consider ourselves to be one-stop shopping for folks in the healthcare industry. For me personally, I was born back east, went to law school at Harvard, and then moved to LA and became an entertainment lawyer. And very quickly, off the record, sort of got sick of the folks in the entertainment business and left and eased myself into the world of healthcare. And it has changed my life. I spend a lot of time working in behavioral healthcare, but not exclusively. And I'm still a litigator, which means lawsuits and disputes and trying to resolve disputes prior to litigation. I'm the co-chair of the litigation department. In addition to things like reimbursement disputes that we'll be talking about today, I also spend a lot of my time fighting with cities over zoning issues, working on whistleblower cases, and dealing with employment situations, contracts, fraud, you name it, I do it. And I really love being in the world of healthcare. It feels truly meaningful to me. A quick note about our reimbursement practice in particular, and by reimbursement, I mean working with healthcare providers to help them get paid. I really consider it a niche practice. I think it requires a really specific knowledge of the area of law. It gets into all sorts of tricky issues, whether it's ERISA or other kinds of issues that are dicey and complicated and very niche. It also requires an understanding of the nuts and bolts of the healthcare, and in particular the billing process and how it works and how the money flows and where the hiccups are. And finally, it really requires relationships with individuals at the insurance companies. The fact that I am a repeat player, folks at my firm are repeat players, I think lends some credibility to what we do, and it really compels folks at the insurance companies to be cooperative, knowing that they're gonna have to deal with me again next week as well. Take it away, Abdul. David, would you advance the slide, please?
Thank you, Zach. Appreciate that. So yeah, I'm one of the owners and founders of CA Billing. CA Billing is a boutique billing company created by us experts in the behavioral health industry. CA Billing is a one-stop shop for behavioral health facilities. By providing all services in-house, we're able to maximize revenue from start to finish. So our expert team carefully and meticulously takes each claim through their appropriate channels. So, a couple of different things that we offer here and what we do: verification of benefits, utilization review, billing and collections, third-party negotiation, reporting, also audits and appeals. I myself am a California native as well. Our office is located here in Newport Beach in Orange County, so not too far away from Zach. And we've been operating for about the past 6 years with CA Billing, and have a ton of experience, dealing with behavioral health specifically. So let's jump right into it.
Next slide, please, David. And sorry, this one's really just for me, Abdul. I apologize, but I have to put this slide in every presentation. This isn't legal advice. Our insurance policy makes us say this. If you do have specific questions that are really unique to you, it's best that you reach out to your own attorney or call me offline so we can set up a more formal attorney-client relationship. Next.
Perfect. Thank you for that. It's very important. So number one, maintain immaculate documentation. So first step being verification of benefits and the documentation needed for that. So my personal experience, doing this for some time now, you want to get these three knocked out: representative's name, reference number, and if possible, record the calls. And I'll explain the reasons why. So if and when you do accept a patient into your facility and you get on the call with the benefits department and they tell you that all benefits are covered, the patient is able to admit, policy is active, everything, it checks all the boxes. And either in the authorization side or the billing and claim side, when you're handling these steps and the representative on the other side tells you that the patient's not covered, you really want to have all bases covered. So when you're getting these reference numbers and recording these calls, you have an opportunity to appeal and fight to be able to get paid, right? There's no miscommunication at that point. It's like, hey, it's pretty black and white. We received the reference number that shows what the representative told us, and we also have the call recorded that was told to us that all benefits were covered, patient is able to admit, so on and so forth. So again, I want to stress how important that first step is, because this is before anything else happens. The verification of benefits is before anything else happens. So if you can do those three things, you have a fighting chance on getting paid, right? So the next one is going to be the authorizations and documentation needed for that. You also want to get a reference number at all times, same deal. Make sure these authorizations line up with your medical records. And I'll explain why. If you have, let's say, for example, authorization for a client that's admitting into the detox level of care, and the medical records are showing that the patient was in residential, let's just say, for example, it's not really adding up. And so if you want a fighting chance to be able to get paid when these insurance companies, they will request these records. It always happens, right? You want to make sure that those two align at all times. So the next one will be assignment of benefits. So it doesn't matter 99% of the time, but it is important to know when a policy won't accept assignment of benefits. That just gives you, another fighting chance to be able to handle these claims, to be able to get paid at the finishing line. Because that's the goal, right? We do all these things to make sure that you can get paid at the end of the day. Out-of-network billing is it's very complicated at times, right? But understanding the steps to be able to be successful at it is a huge benefit. So medical records, just in general, if it wasn't documented, it simply didn't happen. That's the way that we all look at it, and that's the way that insurance companies look at it, right? If a group note wasn't signed off on or was an input for whatever reason, I mean, it's really hard for us to say we know that the client was there. We know he was physically there and he partook in those group activities. But if it wasn't documented, it simply didn't happen because there's no proof, right? Simple. All right. So network agreements and single case agreements. This has been happening more and more and more. Network agreements specifically, right? It's a safety net. It takes really the whole guessing out of the equation. You're able to negotiate a fair rate to be able to, treat the patients at your cost. That's agreeable with these insurance companies, which really helps the facilities be able to, not like I said before, not so much, guess on what they're going to be getting paid and all that good stuff. And they're able to treat a whole lot more of the demographic, the HMOs, EPOs, so on and so forth. And single case agreements as well. If you are looking to get contracted, these insurance companies want to see single case agreements, if possible. And so, if you can, please do. This is probably the most network agreements we've ever done in 2020 itself. My whole years of doing this. So, and I get it. It's definitely adds a huge value and benefit. And so, yeah, if you can and want to talk more about that, we definitely can.
So I want to add a few thoughts sort of from the litigation perspective and really from 30,000 feet. So when I'm handed an issue, right, from Abdul or from a provider directly, it says, look, we've got this issue with the insurance company. We're really struggling to get paid. Sometimes we're able to work things out through a negotiation, but the backdrop is always, if we can't negotiate, if the negotiation doesn't work, we're gonna have to file a lawsuit. And hopefully once we file it, then we can settle it quickly and get you paid. But the backdrop there is always, we may end up having to go to trial. And so always at the end of the day, as a litigator, I'm thinking, how are we going to prove our case to a judge, to a jury? And so there's a couple different theories, and all these documents and your documentation practices are critical to them. So first of all, if you are in network, it's actually a kind of a different ballgame, that your network agreement is really going to be the roadmap for your lawsuit. And it's going to tell you sort of how and when you can sue and under what terms, and you're going to sue for a breach of that contract. And it's I don't want to say it's simple, but it's a little bit different than out of network world. Okay, let's set that aside. If you're out of network, you have two choices, more or less. The first is to sue under the assignment of benefits. And the purpose of that document is to allow the healthcare provider to, quote, stand in the shoes, that's the expression they use, to stand in the shoes of the patient, and to say whatever rights the patient had under their plan agreement, their agreement with the insurance company, all those rights transfer over to the provider. And now the healthcare provider can basically sue as if they were a signatory, as if they had signed that plan agreement. So it is critical that your assignment of benefits is airtight. And there's a lot of ways that insurance companies try to wiggle out of it. And frankly, they've gotten more and more aggressive over the years in trying to prevent you from using the assignment of benefit to sue in the shoes of your patient. So it's critical that you really review carefully with a fine-tooth comb all the ins and outs of your assignment of benefit to make sure it does what you expect that it will do. The other approach, and one that is maybe even more common, I would say, is to forget about the assignment of benefits and instead sue under what's called an implied in fact contract. And the idea there is it says you take all this mishmash of facts and information about the relationship that you've had with the insurance company. And that relationship creates its own contract. And the basis, the backbone, the spine of that relationship is a couple of things. It's the verification of benefits and the authorizations and whatever back and forth you have along the way with the insurance company, whether it's your utilization review department or the calling up the insurance company to get renewed authorizations, whatever it is, that's the spine of our case. So it is critical that, first of all, you have these interactions, you do your verification of benefits, you make sure you have your authorization, whether you have a written authorization or notes from a telephone call, and that you document them perfectly. Because at the end of the day, when I'm in court and I need to stand in front of a judge or a jury and say that my client, the provider, had an agreement, they reached a deal with the insurance company that we would treat the patient in exchange for being paid by the insurance company, I need to have proof of that relationship. And if we're suing under this implied in fact contract theory, which is more often than not what we do, our proof of that relationship, our proof of that contract is the verification of benefits, the authorization, and any related correspondence that shows an understanding that we had an agreement about what was going to happen and that we were going to get paid for it.
Exactly. Yeah.
And if I could, I'm sorry, Abdul, I want to make one more point here about medical necessity. It sort of relates to the medical record, but it's sort of a current event that I wanted to add in that there's a new law that actually just passed in California. It was Senate Bill 855, and it's going to work its way into the Health and Safety Code in a couple of different places. But what it does, in sort of a simplistic terms, is that it's an attempt to expand the scope of what is considered medically necessary when it comes to mental health care. And one of the advocates for the bill described it pretty cleverly, I thought, and said, you'll no longer have to wait to be stage 4 cancer before you get your chemo. Right? You no longer have to be in crisis mode for mental health care to be medically necessary. That's part one. And part two, the way they do it is by trying to standardize the criteria of medical necessity so that individual insurance companies don't have the flexibility to define medical necessity their own way, that there will be a standardized criteria created by independent clinicians that the various insurance companies will have to use in a standardized fashion. So it's a big win for parity. and a big win for behavioral health advocates. And I just wanted to point that out. It doesn't go into effect until next year. David, can you advance the slide, please?
That was amazing. Thank you for that, Zach. That's one of the huge reasons I run everything by Zach. He's a huge wealth of knowledge. Let's just say that.
Thank you.
All right. So here we are. Slide number 2, carefully documenting appeals. All right. So a lot of questions, a few questions that we get asked, why do we have to submit records over and over? And how do we even keep track of that, right? We use our billing software to track all claims and also notate every single time we speak to these insurance companies, right? And we have reference numbers in there. I mean, other people do it through, Excel spreadsheets and other Word documents, whatever it is. For us, it's a lot easier as a billing company to track everything directly in the billing software, in that patient's chart, right? So from start to finish, we have been able to do that. Unpaid, what's it going to take for each claim needing to be appealed? It really is the key to organization for us, right? And also along with that, I mean, you're gonna be speaking to these insurance companies at least once a week until this claim's all the way followed through, right? So you're gonna have a time where the aging for this claim might go above that 120-day marker. So you want to make sure that you have everything in line. And again, it goes back to the documenting and documentation from the VOB standpoint of reference numbers, recording calls. This stuff all ties back in to make sure at the end of the day that you can close out these claims and get paid, right? So next question, what should I submit as part of my appeal? Everything we covered in point number 1 on documentation, verification of benefits, utilization review authorization, and medical records, all right. So you want to be stating all these facts when you are typing up this appeal letter and you're discussing why you believe that the insurance company needs to pay, before we get to that next step of handing this case off to Zach. We want to make sure that we exhaust all options before we have to get to that litigation point, right? And again, documenting, if it wasn't documented, it didn't happen. It's not like, someone was out sick for that day. And so we just want to make sure that, everyone is under the impression that the documentation is the key point of being able to get reimbursed and be in good standings with these insurance companies. All right. How do I know when to stop appealing? Simply put, when you get paid. That's the best way I can put it, right? That's when the appeal process stops. I mean, you're not going to just have one simple first step appeal. It's a second step, or a second level, I should say, second level appeal, third level appeal, so on and so forth. And you stop when you get paid. What do I do if an appeal is unsuccessful? So if all steps have been taken, you can take a litigation avenue if need be. And I'm sure Zach can touch on that as well. But, again, we just want to make sure that we exhaust all options, before we take it to that next step.
So I don't have a whole lot to add here. Most of the appealing is done before I get involved. I just have a couple of quick points. First of all, you have to appeal if you're not getting paid, or else you lose rights. And it's critical that you have somebody like Abdul who's going to be on top of it and be able to keep track of these things, especially when you're dealing with dozens or hundreds or thousands of claims. It's not as easy as it sounds to say, oh yeah, if you don't get paid, appeal it, because you got to keep track. So that's number 1. Number 2 is that if you are in network, there are probably in your network agreement really strict requirements about how and when to appeal and what happens if you don't. So if you're in network, you really want to read that stuff carefully to make sure that you are doing everything you need to do to hold up your end of the bargain, so that the insurance company can't say, well, you sort of waived your rights by not appealing, or not appealing on time, or not appealing in the correct fashion or with the correct documentation. But even in the out-of-network context, where there maybe isn't as clear a set of rules or as clear a roadmap, there is a concept in the law called exhaustion of administrative remedies, which says that you have to sort of you have to do your own self-help up to a reasonable point before you can bug the courts to get involved. And so it's not just a healthcare thing, it's not just a billing thing, it's throughout the law. But in this context, it means you have to go through all the steps of appealing in the right ways at the right times, the right documents, and prove that to the court before you can file a lawsuit. And that's a defense that an insurance company can use. They can say, look, they just jumped right to filing a lawsuit. They didn't do all these other things. They didn't appeal, blah, blah, blah. This case should get kicked out of court, and it will. So it's critical even to a lawsuit down the road that you appeal on time and in the right way. On the flip side, though, one little note of warning, which is that lawsuits have what's called statutes of limitations, which means that depending on your legal theory, if it's a breach of a written contract, if it's a breach of an oral contract, if it's fraud, whatever it is, there's a set number of years that you have to file a lawsuit. And so what often happens, I've seen, is that folks will appeal and appeal and appeal and almost get lulled to sleep appealing. And next thing they know, the 3 years or the 4 years, whatever it is, have passed, and you've lost your opportunity because the statute of limitations starts to run on the original denial in most instances. So that once you get the denied claim or the low paid claim, whatever it is, you only have a certain amount of time by which you have to do all your appealing and then get to the end of the road and say, you know what, I'm filing my lawsuit. And if you take too long, you've blown the deadline basically, and you won't be able to pursue that lawsuit. So one note of caution and why it's important for your biller and your lawyer to be on the same page.
100%.
Next slide.
All right. Slide number 3. Be proactive in dealing with the special investigations unit. Now, a lot to be discussed here, but I'll just kind of start it off here. Why would you be getting investigated? So you probably saw some sort of red flag. You know, it's either medical records didn't match up with the authorization. And most of the time, in my experience, it has something to do with medical records. You know, something that you submitted didn't make sense, and you know it flags something in the insurance companies, and they want to find out more. And you know, honestly speaking, you know, audits in this industry, especially out of network, I mean, they're going to happen. You know, again, you just want to be, you know, ready for that and make sure that your documentation's on point and the medical records match up with the authorizations, right? You don't want to make sure that, you know, if the client was in residential, you're not billing for PHP, you know, sort of things like that. You know, and it's very important. So, you know, incorrect billing as well. You know, if there's a code that doesn't match up, you know, a HCPCS code that doesn't match up with a revenue code, you know, it's going to send a red flag, and they're going to want to know more. And that's usually what medical records requests mean and these audits mean. That just means they want more information to make sure that, you know, the providers that they're paying are in good standing, right? So sometimes insurance providers just investigate some facilities just to make sure that they're compliant. So if you're in good standings with your medical records, and you really have nothing else to worry about. And that's the biggest thing. I mean, that's why we stress you know, documentation. We do documentation trainings at least once a month, you know, however long it needs. It's just, it's important. You know, they release new guidelines yearly. And so, you know, to be able to know what's going on in the insurance world is detrimental in your business, especially as healthcare providers.
It's funny. I'm actually, I think I'm more cynical than you, Abdul. I really think that these special investigations units are considered profit centers at insurance companies. I think they're out there to cut costs, and I think they're out there to recoup and bring in more revenue.
Mm-hmm.
I think they target profitable providers. I think they're constantly running numbers and seeing who's costing them a lot of money, who's billing them high dollars, whether it's you know, a lot of clients or just high dollars for particular revenue codes, and they're going out and I don't want to say harassing them, but they're checking in on them. and potentially flagging them for audit. And I think they target out-of-network providers, out-of-network behavioral providers, perhaps more than anyone. And one of the goals there is to squeeze out-of-network providers so that maybe they go away or they end up going in network, with the ultimate goal of pushing their own members to stay in network, because that's where they save the most cost. The more that the insurance company's members are treated in network as opposed to out of network, the more profitable the insurance company is going to be. And of course, they recoup wherever they can, and we'll get into some of that in a couple of minutes. But what I see is a constantly evolving list of tactics and hot issues and what I've come to call battle lines of what kinds of issues they're going to start spotting and looking out for and demanding documentation on. And it's really critical, and I'm going to harp on this for the next half hour, that all of you out there talk to each other, talk to us, compare notes, and so that you all know how these battle lines are evolving and how these hot topics are changing, so that you can stay ahead of them.
Yeah, I mean, I love that. It's really good. It's really smart to be proactive in situations like this. If we know something's coming, I mean, most of the time when we see a certain payer start to change some sort of guideline or start to request more records, it's a trend. That's kind of what we define it as over here. And when we see some sort of trend, we know a change is about to come.
Yep.
And it's important, and it's just like Zach said, it's vital to be able to watch these things and be able to know exactly what's going on in your industry, right? All right. So prepayment review. What is a prepayment review and how do I get off? So in my opinion, it's the step before an audit, right? It's not that the insurance carrier is going to completely stop paying you, but what they're going to want to do is review every medical record before they process and pay that claim. So obviously, with that being said, that's going to slow down the revenue cycle for a period of time until you're able to get out. And so, you have to build the claim out. You have to wait for the insurance company to respond with that medical records request. And at that time, you send in the medical record for each claim submitted with the response from the insurance company. And after that happens, they review the medical record. And if they deem that it was medically necessary or approved, that's when they process it for payment, right? So instead of a claim being processed in the 30 to 45 day marker, now you're looking at anywhere from 60 to 90 days plus, because they are having to review that. And so, the way to get out, in my opinion, honestly, submit all medical records in a timely manner and just be patient. Just be compliant at that point. There's really nothing you can do. If anything, the representatives that we're speaking to on the other line, most of them are offshore somewhere outside of the U.S. And they're not that high up knowing, exactly what's going on. So that's why I say just be patient, submit these medical records and process the payment, or let them process the payments. And, and if the issue concerns, then you bring in someone like Zach to be able to help out. But again, you just got to exhaust all options to be able to happen. But these prepayment reviews, it just takes time. You might get out quickly, you might get out slowly. But it really just falls in line of the medical record quality and how quickly you can get them submitted.
Yeah, I don't disagree with anything you said. I guess my view is a little bit different only because of where I sit, that I tend to not deal with the ones that go smoothly. So my best advice is to figure out exactly why you're on prepayment review and exactly what needs to happen for you to get off of prepayment review. And a lot of insurance companies have something called quote unquote provider education. And it is critical that you do everything you can to have that provider education. It's usually a phone call or a conference call. I guess pre-COVID, it could have been a meeting, but some form of formal provider education where they will walk you through what they think you're doing wrong. And there's two really important reasons why you need to do that. The first is you just need to know what's broken so you can fix it. there's sort of a psychological deterrent to hearing bad news. You don't want to get on that call because they're going to tell you all these things you've done wrong. The alternative is terrible. The alternative is you don't know what you're doing wrong, you keep doing it wrong, and your claims continue to be denied. And that's not where you want to go. So it's so important for you to be proactive, have that provider education, and figure out what it is that they think you're doing wrong so you can fix it. But the other reason why provider education is critical is that, at least in my experience, I've found that the insurance companies aren't perfect either. And there's often, whether it's on purpose or by accident, they think there is a problem when really there isn't. And it's called provider education, but sometimes it really turns out to be insurance company education. And it's the provider explaining to the insurance company, no, you're just misunderstanding how I'm doing my documentation. You know, here's the authorization. It just happens to look a little different than you're used to. Whatever it is, where you can actually straighten it out and show, look, I'm not doing anything wrong. You just need to understand exactly what I'm doing. And then second, maybe third by now, there are typically very concrete metrics for when and how you get off of prepayment review. It's sometimes as simple as, a certain percentage of claims that are deemed payable, at which point you're off of prepayment review. You want to know what that is. You want to know exactly what that is so you can track it on your own. And if you hit that 80% number, whatever it is, you want to make sure you're reaching out to the insurance company, that they have the same number in front of them and that they're going to do what they promised and take you off now that you've met their metrics. And lastly, the reason it's so critical to get off of prepayment review, aside from what Abdul said, he's 100% right, it slows down getting paid. It's not just that. I've found that these kinds of prepayment reviews where they're looking, where you're opening the kimono and showing them all of your records, it turns out to be kind of a fishing expedition, that they may have put you on prepayment for one reason that you end up resolving, but through their review of all of your medical records, they've come up with something else. And in our office, we say that it's like a game of whack-a-mole, because they're just a different thing will pop up every time. And so the longer you are consistently giving them all of your records, the more problems, the more potential for problem that there is. You want to get off and be done with it and go back to business as usual. Abdul, you want to talk about the case study?
Yeah, thank you for that. Absolutely. All right. So the case study, Cigna retrospective review. So this has definitely been a hot topic in our industry as of recent. And so essentially, what that kind of looks like, Cigna, as of recent, what they've been doing, sending out a letter, not so much of a scary audit, but just requesting medical records. Let's say the example of about 10 patients. They review those patients' charts and come up with what they see as non-medically necessary. And with that comes a huge refund request, in the millions. Most of my providers have gotten in the millions, right? And honestly, even with having the best medical records, doing everything by the book, and I heard Zach say it earlier, it really comes down to be a shakedown. And it's honestly pretty sad, but what we have done is being able to show them that this is medically necessary. We do have authorization. These documents were completed in a timely manner, and all these things, right? It kind of just starts back from the beginning of the verifications to the authorizations to the claims to the medical records, all these things. And when situations like this do arise with Cigna or whoever it may be, you're able to go back with them and say, hey, no, like I did everything. I'm looking at your guidelines. I'm looking at, all the medical records we sent out, and it's all making sense. So, and that's where I turn it over to my man, Zach, over here. And he really takes it to the next level. But, again, we work in tandem in these situations, just because, if the records and the data and all these things don't match up, he can't do what he needs to do in the courtroom to be able to make this stuff go away, or, a settlement happen.
Exactly right. I mean, I think we're on a call together just the other day with a mutual client. We really do work hand in hand, and I don't think either one of us could do it without the other. What I'm seeing, just like you, is Cigna really hitting hard with these, and I think it serves them two purposes. I think first, in certain instances, it does force compliance with whatever new policies or procedures they're focused on. And of course, it's a source of revenue. Exactly right. We're seeing a lot of repeat topics as well. And some of the things that stick out just real broadly to me have been medical records related issues supporting the level of care, medical necessity, things like that. A lot of UDT, drug testing kind of stuff, the frequency, issues with standing orders, and then recently some what I'm calling clinical supervision issues, giving your initial assessments and evaluations within the right amount of time upon admission, the history and physical, coming up with an individualized treatment plan. Things like that are I'm finding increasingly hot topics for whatever reason. I wanted to say that I think in this issue, when you get something like this from Cigna, it's critical to get an attorney involved, because there's a lot of stuff in these letters that sound scary and sounds strong that really aren't. And it takes somebody, I think, with some legal knowledge, but also just a repeat player, to know what is real and what is not. There is often a lot of really low-hanging fruit that you can push back against. Just as one example, there are very clear statutes of limitations. I described what that was before, on when an insurance company can come back to the provider and demand a recoupment. And what I've seen is that in these Cigna letters, they just ignore that. They go back years and years when they know they can't. Because you know what? Some people might just say, forget it. I don't want to fight this. I don't want to hire a lawyer. I don't want to dig into it. I'll just write them a check. So they make every argument they can, whether there's a basis for it in the law or not. And that's true. And that's just the statute of limitations is just one example. And I wanted to make just a couple of real quick notes on SIU interaction generally. First is, I have seen in a lot of instances the insurance company trying to get providers to sign a pre-prepared affidavit. Usually it comes along with the production of documents. Sometimes it's swearing that these are all the records, and there's no, et cetera. It's a sign that, at least without having an attorney review it. Situation where that has foreclosed a provider providing additional records. They didn't realize there was a whole other batch of medical records that they accidentally didn't produce that would have supported all their claims, but they signed this affidavit saying there were no other records, so they weren't allowed to send in that second production. A bunch of claims got denied just because they had signed that document. Second, at the end of some of these audits, not always, but sometimes, there is the insurance company will propose a written agreement to talk about how you're going to behave going forward. And that may be okay in certain circumstances, but it's so critical that you read that with a fine-tooth comb, because there's all sorts of stuff in these agreements that you may not be focused on because you need to sign it in order to get paid, and you're focused on getting paid. That's just going to be disastrous for you going forward. So again, read it extremely carefully. If you can, get a lawyer involved to review it with you, so you know all the ramifications. And then third, I keep hearing about SIUs showing up for unannounced visits, and people call me in a panic as if it's the SWAT team knocking on their door. And SIU likes that. That's what they're trying to convey. They want to almost intimidate people into opening up the door. You don't have to do that. Tell them no. Tell them to call your lawyer. You may still have to allow a site visit, but not unannounced. They show up at your door and force their way in. They're not the police. So with that last comment, I'll turn it back over to you, Abdul. Next slide, please, David.
Thank you for that. All right. So this next slide over here, financial hardship. So billing companies typically don't deal with these situations. We do discuss the legality and the importance of it with our facilities, but usually I always refer back to Zach and his team to discuss how to handle these situations.
Sure. So I'm going to spin through this relatively quickly. I want to be sensitive to the time here. Here's the litigation perspective, is that this patient financial responsibility stuff is one of the most frequent go-to areas that insurance companies use to deflect their responsibility to pay claims. I can't, in every single dispute, sort of formal dispute, litigation or an arbitration or something that I can think of, the insurance company raises this issue as a defense. So we have a lawsuit, we have 100 claims that didn't get paid for a claimed lack of medical records, or let's just say hypothetically something like that. 3 years after, we're deep in this lawsuit, we're getting towards trial, and they say, well, forget about the medical records stuff. Here's the real issue, is that you never made your clients pay their share. Apropos of nothing, totally unrelated to what we've been talking about all along, but they'll always come back to this financial hardship stuff. So it's critical that you get your ducks in a row. And here's the two major issues. The first is, what do I do when my clients can't pay? And the issue is, and the answer is, you can have a financial hardship program. We advise clients all the time on setting up a financial hardship program. Look, it's the reality of the industry we're in, that we've got clients who are not going to be able to pay their share. And that's okay, but it has to be carefully structured and carefully carried out. You need a concrete written hardship policy and procedure and guidelines that you follow to a T every single time. And I'll tell you that we've taken our standard policy and procedure that we recommend to some of the insurance companies, just out of curiosity. Hey, what do you think about this? Is this going to be a problem for us down the road? I'm sorry, I've got ambulance going by down the street here. And they've generally blessed it. So there are certain hardship policies that even insurance companies will tell you, yeah, that's fine. And generally, the guidance is this: you need to have a written program that explains exactly how it works. We recommend a sliding scale of responsibility. Ours is based on the federal poverty level, but I'm sure there could be some other metric that you use, but it needs to be tied to a clear metric. And you need to require your clients, upon their admission, to prove their financial situation, and you need to be able to document it. Where possible, that means a written application. Well, I guess that always means a written application, but where possible, that means bank records, W-2s, and whatever other information your client may have, documentation your client may have about their financial situation. And the application needs to be signed by the client, and it needs to be carefully maintained. You should never advertise your hardship policy. You shouldn't treat it as a matter of course that every client who comes in the door is going to apply and be rewarded with financial hardship. It needs to be a real concrete test, so that if you are ever audited, or you're ever in one of these lawsuits where suddenly the insurance company is raising it as a defense to having to pay you, you are able to document for each and every client that you're talking about, or that has come in the door. Here's their application. Here's how they filled it out. Here's the documentation they gave us. Here's why we decided to give them this hardship at this percentage. Mm-hmm. Absolutely critical. And the second question, I'm going to split through this very quickly. The second question we often get is, well, what happens if, even with the hardship or without it, I can't collect? Try to collect, but I can't. And the answer is there's a term of art for this: commercially reasonable efforts. Folks think that all you have to do is send 3-form letters. I don't know where that old wives' tale got started, but that is not the end all and the be all. Sometimes that's enough, sometimes it's not, but that's not the answer. The answer is you need to make a case-by-case business decision that would be looked at by a reasonable person and say, that sounds like a smart business decision, of how hard to try to collect. If you have a huge balance due from somebody who has the money to pay it, you need to go after them, and 3 letters is not going to be enough. But by contrast, if it's a small balance due, or if it's from someone who you know is unable to pay it, then three letters is probably plenty. But it needs to be a smart, commercially reasonable business decision that you're acting on, and you're going to need to be able to prove that each and every time. And like always, document everything from the hardship application and whatever they give you in connection with the application to all of your attempts to collect. Document it so that I have the evidence when I need it. Next slide, please, David. I think we're on to the last topic here.
All right. Maintain data to know where you are and where you're headed. So, the data is, for a billing company and a company like myself, is where we live and die by. So it's really important that we do collect this, not only for us, but for our clients as well. So why should we be collecting the data? So paid claim data, you can utilize past payments and revenues collected to gauge if collections are remaining constant, and use it to make adjustments moving forward, right? And you can always see where you're at. If one payer is, slowing down on payments that you're, used to getting more from on a weekly or monthly, whatever it is, you can look further into that. Is there, a prepayment review coming? Is there an audit coming? Whatever the case may be, the data really speaks for itself most of the time. And so we can always, look at that. And so what data should I be collecting? Paid data, frequency of paid claims. What's the frequency that you're getting paid? Is it 30 days, 45 days, 60 days? All payers are different, but if it's out of the norm, what's going on? Like I said, is it a prepayment review? Is there an audit coming? Whatever it may be. Also keeping track of, certain prefixes that you've been previously paid on, right? To tie in the advantage of using CA billing, we work with a plethora of different clients and have an abundance of data and prefixes. Out of network policies can become really a guessing game, and tracking prefixes can take out some of the guesswork, right? And if a certain prefix at one point with one patient was paying you, this amount, let's call it $1,000 a day, and another one, same exact prefix, but it's paying you $500 a day. There's something obviously wrong there. You need to be able to go back to these insurance companies and prove that point, right? And not just sticking with, the low hanging fruit, as we call it, right? Being aggressive and making sure that you're not getting stiffed by these insurance companies, because if it gets overlooked, it gets overlooked, right? And we make sure to track every single dollar and penny that comes into our system to be able to make sure that, we're collecting the most for our patients, and also making sure that the patient responsibility isn't getting too high either, right? So, and keeping track of the prefixes that didn't pay as well, that's huge. If a client came to you before and, they gave you a hard time of medical records, or, denials or authorizations, or they gave you a very short stint of authorizations, you might want to go into the private pay private pay side, or, you can try it again, but at least you're not looking in the dark, right? That's the most important piece of this whole deal, and why the data is so critical. Just the medical records, same thing, verification of benefits, the rest of it, this data is just as important. So being able to track if you got paid different amounts, and making sure that you can, really start to, plan for your business, on a monthly basis. If you know on the front end how much you're going to be receiving, you can make some real business decisions for the next month, for expenses or whatever it may be. And that's kind of what we provide here as well. Making sure that, we can go through a full week's of billing and make sure that exactly what's going to come to you, besides the patient responsibility, which we can include as well. But it's very beneficial. Running a business like this for out of network, there's a lot of guessing involved, not knowing how long it's going to take to get paid or when those claims are going to close. But this helps take a lot of the guesswork out of it.
I like to say that there's sort of two reasons to maintain this kind of data. The first is that data, I think along the lines of how you're describing it, data is like the coordinates that you might use for navigation. That without your data, you don't really know where you are, so you can't figure out where you're going. You can't tell that there's some kind of trend if you're just kind of flying by these coordinates and these claims coming in and having no way to put it all together. So for example, if a particular code got you, 20% of your claims on a particular code were denied this year, as compared to 10% last year, I guarantee you wouldn't notice that unless you were keeping track. And it turns and there's so much value in being able to notice that and keep track of it and respond to it and stay ahead of it and fix it. So that's sort of number one. Number two is that for me, it's really the arsenal that I can use in the event we need to fight. And I'll tell you, it's the spreadsheet, the PowerPoint here says Zach's fantasy spreadsheet, and I really do. I dream about this stuff. And on every case, I reach out to my client, and we spend a lot of time putting together, or hopefully just cleaning up, a spreadsheet that has all the data I'm going to need to make our case, whether it's just in a negotiation or whether it's proving a case at trial. And I just want to quickly spin through what that data is. It's the patient information, of course. It's the verification of benefits information, the date, the plan rep, all the stuff we talked about earlier, the basis for the out-of-network rate, the patient's financial responsibility breakdown. It's the authorization information, same date, plan, the rep from the insurance company and the reference number, the exact services authorized, the time period, any follow-ups. Then it's the claims information, like your own internal tracking number, the plan's claim number. And the reason both of these are important is that oftentimes you are forced to rebill a claim, and the insurance company may give it a new claim number, but you've kept the same number, and it creates a mess. So it is critical for you to maintain both. The CPT or revenue code, the claim submission date, any medical records submission date, or the method you're submitting the medical records, if applicable, meaning if you're under prepayment review or for some other reason you need to submit the medical records, the billed amount, the allowed amount, the paid amount versus the patient's responsibility, the denial code and the reason for the denial. Sometimes it's just a code. Sometimes there's also sort of a written denial reason. I need to have both. And any appeals data about when and how you've made the appeal. And my last point here, and this is sort of my closing thought, is to compare notes. And I talked about this earlier. We're all in this together. And what I find time and again is I'm always the David going up against Goliath. And the only way we can advance the ball in a meaningful sense is if we work together. Knowledge is power in this industry and in every other. So I really encourage you. I realize this wasn't quite a conversation, it was sort of us talking at you, but have conversations with each other, with your lawyer, with your biller, compare notes, understand what the trends are. You know, I handled the Cigna audit this way, you handled it that way. What worked better? I stopped billing this code and started using this one instead, and let's talk about why. And these are hard times to do that, right? We're not having the conferences that we used to have, but you got to make that effort. I understand that all of you out there are technically competitors, but in a sense, we really all have the same goal here. It's been inspiring to me to see the teamwork and camaraderie in this industry. You know, I've only been doing this particular industry for a handful of years, and it's really been inspiring to me to see how everybody works together for the common purpose, even though you're technically competitors. And even in these times, it's critical to all of your businesses and to the industry as a whole that cooperation and communication persists. If you'd advance the slide, we tried really hard to set aside a few minutes for questions. We only have like 3 or 4 minutes. So the one I saw in here was about the statute of limitations. And the question is, you know, what is the statute of limitations for out-of-network versus in-network? And the answer there is, that, of course, that it depends. It depends on the legal theory that you're suing on. So if you have a contract, I guess if you're in network, you're probably suing on a written contract, right? The network agreement. And when you're suing on a written contract, you typically, at least in California, I don't know how many of you are from out of state, but in California, you have 4 years from the date of the denial. If you're not suing on a written contract, it really varies. If I talked earlier about an implied contract, for example, an implied in fact contract, that's just 2 years. So it really depends, and it really is to your benefit to stay on top of it, talk to your lawyer, make sure there's an understanding with your lawyer of what your theories are going to be so that they can tell you when you need to file your lawsuit by.
All right, let me see.
I'm not, well, let me say this. If we're missing anybody's questions, just reach out. I think, David, if you advance the slide to the end, I think our contact information should be on there. Yeah, there we go.
There it is.
Phone number, email, reach out to us. We're here, we're around, and happy to talk. I think both of us, speaking for Abdul, we love this stuff and could talk about it all day. So please don't be shy.
Yeah, please do. Thank you for that, Zach. Yeah, I mean, there's a lot discussed, I know. So if you have questions, again, just to touch on Zach's last topic, we are in this together. We want to help, even if I'm not working with you directly, it doesn't matter. We have one common goal, and we don't want to get screwed by these insurance companies, and I don't want to see it happen, so please reach out to me, text me, email me, whatever you need. I'm here for you. And thank you guys for your time today.
Yeah, thank you all very much. And thank you, Abdul. This was fun.
All righty. Have a good day.